But what is title insurance? After taking a quick look at the unique features and characteristics of land ownership, it becomes quickly evident that landowners need some form of protection against the potential rights of others against their property. That is why title insurance was developed. But what exactly is title insurance? Legally, title insurance may be defined as a contract of indemnity against loss or damage arising out of defects in or liens upon the title to real property. Don't worry, that will turn into English soon enough. But before we examine exactly what title insurance does, it might help to look at how it came into being. As we said before, even in the earliest human civilizations, land was considered different from other forms of property. Land is unique in that it is permanent, immovable, and indestructible. Thus, even ancient civilizations recognized the need for some form of assurance that the land they owned was actually belonging to them. We call this title assurance. Throughout the ages, title assurance has been whatever precaution real estate owners have relied upon to make sure their title was secure. The earliest form of title assurance in this country was often simply an oral agreement on the part of the seller assuring the purchaser that the land was theirs. Over time, purchasers' desire for greater security led to the development of written agreements and legal documents to legitimize their claim. One such document, called a full covenant and warranty deed, included language holding the seller liable for any encumbrances or defects in the chain of title. Over time, and with the development of an organized recording system in the U.S., purchasers were eventually able to take the next step of actually examining the back chain of title for themselves to determine the validity of their potential claim to the property. This was sufficient assurance for purchasers for a time, but as the economy progressed and the law grew more complex, the need developed for a more reliable process of land title assurance. This is when the first American title assurance professional, the conveyancer, made his appearance. The American conveyancer was a professional individual such as a justice of the peace, judge, real estate dealer, or lawyer who was better equipped to give advice regarding land title matters than the average citizen. These conveyancers would examine the recorded chain of title and issue an opinion as to the strength or legitimacy of a particular title. These opinions were first given orally, then later in written form. Over time, the opinion of title that these conveyancers issued was transformed into a formal document called a certificate of title. As the business of title assurance became more lucrative and competitive, the public justifiably began to regard those conveyancers with a legal background as better qualified to render valid opinions on titles. Soon, attorneys were fighting to make the rendering of title opinions a practice of law, and therefore off limits to non-legal title professionals. However, the research and compilation of public records regarding the back chain of title was still a viable industry for those conveyancers who were not lawyers, and thus the abstractor was born. And his handiwork, known as the abstract of title, came into use. Soon, abstractors and lawyers were teaming up. The abstractor would compile the data, and the lawyer would examine it and render an opinion on the state of the title as a whole. This was the final stage of title assurance prior to the development of title insurance. There were many reasons that these early methods of title assurance were considered insufficient to protect the interests of the purchasers. Title insurance did not develop out of nowhere. It was born to address the specific needs of the public that weren't properly protected under older methods of title assurance. The greatest deficiency in early title assurance methods was their reliance on public record for information. The public records are only one reservoir of facts that must be reckoned within the process of title assurance. Therefore, a recording system, however perfectly devised and executed, is not an absolute assurance of the state of the title. For the purposes of analysis, rights in land may be divided into three categories. First, there are rights that are reflected in written form, public records like deeds and wills, for instance. Second, there are rights that are not reflected in written form, but exist as the consequence of statutes, laws, or precedents. These rights cannot be found in public records, but they can be ascertained to a certain extent through other means, such as a physical inspection of the property. If, for instance, there is a path running across a piece of land that may indicate an easement across the property. You might not find the easement in a recorded document, but its existence is evident. Finally, there are rights that are completely undisclosed and unascertainable, but are as legitimate as any other rights. Rights existing because of forgeries, insanities, unknown heirs, legal disabilities, and false personations are all captured under this segment. Keeping these three categories of rights in mind, the fundamental weaknesses of the title abstracts and opinions as a form of title assurance become obvious. First, title abstracts and opinions were based only on that segment of title rights reflected by public records. No opinion was given, no information was provided, and no protection was offered regarding those potential rights that were not recorded in written form. Second, these methods of title assurance have always been subject to human error. Title opinions can be no better than the abstracts upon which they are based, and neither abstracts nor opinions were required by law to be perfect. So long as the professional exercised reasonable care and skill in performing his duties, those mistakes or omissions that were the result of unique, complex, or confusing situations would not necessarily be held against him in a court of law. Finally, collection of money to cover legitimate title losses was often difficult. There is a statute of limitations for a suit against the professional that runs from the date he delivered his abstract or opinion, not from the date that the loss was discovered. If a loss was not discovered in a reasonable amount of time, the injured party would not be able to seek retribution from the professional in question. Furthermore, the ability to recoup a loss was directly limited by the financial ability of the professional to pay. Dead, defunct, bankrupt, or even practicing and financially stable professionals often did not have the financial resources to make an injured party whole. The weaknesses of the abstract and the title opinion were of little consequence or concern when they first became popular. For several generations they served well the cause of title assurance. But like the methods that they supplanted, their deficiencies became more apparent and material as the social order progressed and the use of land expanded. The next step in the evolution of assurances was the development of title insurance, and without getting bogged down into the historical muck that was the early years of our industry, it is sufficient to state that title insurance companies developed independently in many major cities across America, that their operations were often confined to a small geographic region like a city or a metropolitan area, and that at first there was no government regulation of the industry whatsoever. In the beginning, each local title insurance company operator had his own individual ideas with respect to the theory of title insurance. The coverage of risks that should be undertaken, the forms and provisions of policies, rate structures, and the underwriting principles that should be followed. As a result, there were about as many different kinds of policies as there were companies. But the courts quickly recognized the evil and confusion that would eventually develop from these conflicting underwriting theories, and they took a firm hand in bringing order out of the chaos. Today, it is established that a contract guaranteeing a title is one of insurance, and must follow the rules applicable to other insurance contracts. As a result, title insurance companies come under the control of state insurance regulations. In many ways, today's title insurance policies function like any other insurance policies. However, the title insurance has one characteristic that is still unique. It is the only insurance that protects individuals against loss or damage arising out of matters that have occurred in the past, rather than those that may occur in the future. Therefore, the risks of title insurance end where the risks of other types of insurance begin.